Okay, guys! Good day, ma'am! I am MALINAY from the Philippines. CRIS!
So, dun po sa video na pinanood po namin is tinalakay po dun yung second pillar, which is the prosecution. So, what is prosecution? Prosecution is a course of action or process whereby accusations are brought before a court of justice to determine the innocence or guilt of the accused. So, dito po sa prosecution is, bago daw po dalhin sa court, is dinadala muna sa prosecution. So, in prosecution, dito pina-file and pina-prosecute yung case in court, and then dina-determine the innocent or guilt of the accused, gather the necessary evidence with the help of the law enforcement, and then dito din po dina-determine yung existence of prima facie case. Ito po yung basihan na meron talagang crime na nakumit. And then, ano naman po yung role of prosecutor? Ang role po ng prosecutor is serving as the lawyers of the state or government in criminal cases. The prosecutor is automatically considered as an officer of the court. At the same time, the prosecutor is formally a member of DOH or Department of Justice under the executive branch of the government and is thus independent from the judiciary. So, ang role daw po ni prosecutor is, sinasabi po na siya is yung abogado ng people of the Philippines at representative ng gobyerno sa mga criminal cases. And then, sinabi din po dun sa video yung pagkakaiba ni prosecutorial discretion at ni selective prosecution. So, si prosecutorial discretion po is the prosecutor screens and evaluates the document in order to decide whether to accept or reject the case for prosecution. So, in prosecutorial discretion po is, dito po ine-evaluate yung documents, whether it is sufficient na mag-file ng case, ng kaso. Then, in selective prosecution naman po, it is the responsibility of the prosecutor to evaluate the evidence that the police have gathered and decide whether it is sufficient to warrant the filing of charges against the violator. So, in selective prosecution naman po is, dito po ine-evaluate yung evidence if sapat na mag-file ng charges laban sa suspect. And then, next naman po is the legal factors in selective prosecution. So, yung mga legal factors po is this trend. The suspect is in fact guilty. And then, the willingness of the witnesses. And then, the prosecutor can legally prove the defendant's guilty. And then, the controversial expression of prosecutorial discretion po is the decision to mitigate the defendants through reducing the charge, nire-reduce po. And then, dropping multiple counts to leave a single charge, recommending leniency to the court at sentencing para prison sentence. And then, the composes of the prosecutor. Meron po tayong public prosecutor o yung tinatawag nating fiscal, the state prosecutor, provincial prosecutor, city prosecutor, special prosecutor, and then meron po tayong attorney in private practice, public defender such as PAO. So, yung PAO po natin is the Public Attorney's Office, headed by the Chief Public Attorney, and then 8 members provide free legal assistance to indigent and poor litigants. It is organized by RA 9406, otherwise known as the PAO Law of 2007. And then, so yung private lawyers should also be deemed as part of CJS prosecution pillar because they already represent the parties. So, next naman po natin is the roles of prosecution. So, ano nga ba yung roles of prosecution? Evaluate the police findings referred to them or other complaints. File directly with them by individual person. So, yun po, evaluating the findings of police and then file corresponding criminal complaints or information in the proper court on the basis of their evaluation on the proofs at hand. So, yon file information in court na base sa pinanghahawakan nilang evidence or proof. And then yung last is prosecute all alleged offenders in court in the name of the people of the Philippines. So, yun na po. Diga po kanina yung sabi ko is yung prosecutor is yung abogado of the people of the Philippines. Siya yung kinatawan ng gobyerno. And then, so, ang next naman po natin is the preliminary investigation. So, ito po is duties of prosecutor kung saan kailangan po mag-conduct ng preliminary investigation. So, ano nga ba ang preliminary investigation? An inquiry or proceeding to determine whether there is a sufficient grounds to engender profound belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. So, it is required to be conducted before the filing of the information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. So, ang preliminary investigation po, siya po yung nagdedetermine ng probable cause. So, ano po ba yung probable cause na sinasabi natin? Ang probable cause po is the existence of such facts and circumstances as would excite a belief in a reasonable mind, acting on the facts within the knowledge of the prosecutor that the person charged is guilty of the crime for which he is prosecuted. So, ang probable cause pong sinasabi natin is ito po yung dahilan para mag-file ng information sa Court of Justice kung na masabi na yung taong yun is nakakommit ng crime nga. Then, so, may mga officers authorized to conduct preliminary investigation. So, yung provincial or city fiscals and their assistants, national and regional state prosecutors, such other officers as may be authorized by law. And then, yun yung preliminary investigation. So, ano naman yung purpose of the preliminary investigation? So, ang purpose nito is to protect the innocent against hasty, malicious, and oppressive prosecution, then to spare him from trouble, expensive, and anxiety to a public trial, and then to protect the state itself from useless and wasteful rights. So yun yung mga purpose ng preliminary investigation, yun to protect innocent, to spare him from trouble, and to protect the the state itself. So, dun din po sa video is may may sinabi, may binanggit na yung nolle or nolle prosecute. So, ito pong nolle is a request made by the prosecutor to the judge for approval to terminate further criminal prosecution against the suspect. So, ito daw po yung request na ginawa ni prosecutor para kay judge para ma-terminate yung taong yon against the suspect. I-terminate yung kaso against the suspect. Then, the arraignment. Arraignment is the legal mechanism whereby an accused is brought before the court wherein the complaint or charge against him is read by the clerk of court in the presence of a lawyer and the prosecutor, in which the accused is to announce his plea. So, yung arraignment is, ito po yung pagbasa ng sakdal. Kasi meron tayong right to be informed in the presence of lawyer and prosecutor. So, dito po babasahin yung arraignment, yung sakdal. So, yung sagot po ng accused, kung guilty siya or not guilty, ang tawag po doon is plea. So, yun po, ang tawag po doon is plea. And then, may tinatawag din po tayong plea bargaining. So, ito po is yung kasunduan ng prosecutor. Ang plea bargaining po is the process of discussing or negotiating between the defense counsel and the prosecutor aimed at reaching an agreement whereby the prosecutor uses discretion to obtain from the judge a lighter sentence in exchange for the defendants entering a guilty plea. So, yun. Sinabi po dito na ito yung kasunduan nga po ni prosecutor at saka ni accused. Kapag po umamin si accused sa nagawa niya is mababa po yung sentensya o mababa yung hatol sa kanya. Sinabi po doon yung example na imbis na murder, magiging homicide na lang. So, yung plea niya is plea ng accused is guilty kasi umamin na siya. And then, next naman po is yung advantage of plea bargaining. So, it allows the court to control overcrowded dockets, allow the prosecutor to secure convictions in bad arrest, necessary discretionary tool for tempering the letter of the law with an individualized justice, acts in the best interest of society rather than on behalf of the victim, and then save victim from humiliating and trauma. There is no trial. Then disadvantages of plea bargaining is lowering of cases, demoralize the police. Yan, provides an opportunity for the prosecutor and defense counsel to place their economic and occupational needs ahead, and then mostly in favor of the defendant. It is not an evidence of repentance, legitimacy of punishment and rehabilitation, and that undermines the basic premise of crime and punishment, destructive of the adversary method of justice, and the defendants are dissatisfied. Yun po yung advantage and disadvantage ng plea bargaining. And then, next naman po is binanggit din po sa video yung pinagkaiba ng complaint at information. So, ang pinagkaiba ng complaint at information is yung complaint is a sworn statement charging a person with an offense subscribed by the offended party and any peace officer and or other public officers charged with the enforcement of the law. So, itong complaint po is yung pagrereklamo po, which is fina-file. Ito po yung statement na fina-file sa prosecution. Then, subscribe siya or ang pwede mag-complain laban sa taong yan or sa accused is yung offended party or yung victim. Then, the public officer, peace officer. And then, yan. And then, ang information naman po is an accusation in writing charging a person with an offense subscribed by the fiscal and filed with the court. So, itong information po, kung ang complaint ay ito is pina-file sa prosecution, ang information naman po is pina-file sa court. So, pinapermahan lang siya ng public prosecutor. So, yun nga, subscribed by fiscals o yung tatawag na public prosecutor. Then, yan. Next naman po is the prima facie evidence. So, yung prima facie evidence po is such as establish a fact and unless refuted or explained by evidence becomes conclusive and it is considered as if fully proved. So, denotes evidence which, if unexplained or uncontradicted, is sufficient to sustain the proposition it support or to establish the facts as to counterbalance the presumption of innocence to warrant a conviction. So, ito pong prima facie evidence is, sinabi po sa video, is yung paunang impression po. So, ito is yung evidence na kapanipaniwala or totoo na inihain na masasabing meron nga talagang nangyaring krimen. Yun yung prima facie evidence. So, evidence siya na totoo na kapanipaniwala na inihain na masasabi na meron talaga nangyari na krimen doon. Tapos, binanggit din po sa video yung other officers authorized by law. So, yung mga COMELEC, which is conduct preliminary investigation on all election cases under the Omnibus Election Code 1987 Constitution, mandates the COMELEC not only to investigate but also to prosecute cases of violation of election laws. So, ang COMELEC po is sa lahat ng election cases. So, conduct and prosecute yung mga nababiolate sa election cases. And then next po is yung PCGG, prosecution for violation of RA 3019 rather, an anti-graft law, and the RA 1379, the unexplained wealth. The Office of the Solicitor General can legally represent respondent government officials in preliminary investigation in the prosecutor's office on charges of violation of anti-graft law. So, PCGG, yun nga, yung pag-violate ng RA 3019 at saka RA 1379. And then, yung Tanod Bayan and his assistants. Itong Tanod Bayan is yung tinatawag na ombudsman, which is sila yung nag-investigate and prosecute ng Philippine government official na nagko-commit ng crimes. So, sila doon. And then, yung national and regional state prosecutors, provincial or city prosecutors and their assistants, yun, special prosecutors. Tapos, binanggit din yung military tribunal. Yun yung governed by the Articles of War. And then, yung huling-huli po is yung tungkol sa mayor na bawal yung mayor na mag-conduct ng preliminary investigation and mag-issue ng warrant. So, under local government code yon. So, yun lang po lahat. Pinakabuod nung video na pinanood ko po. Yun po.